Every single day, thousands of tons of cargo are lifted off solid ground and placed onto vessels bound for the other side of the planet. The moment those goods leave the breakwater and hit the open ocean, the financial risk skyrockets. An entirely calm voyage can turn into a total loss from a sudden storm, a fire, or a navigation error. To keep a single lost shipment from bankrupting a company, the industry relies on marine insurance. This creates a financial safety net designed to absorb catastrophic losses. Buyers and sellers are willing to execute massive contracts at lightning speed, strictly because they trust that this protection is in place. Take away the guarantee of compensation for a destroyed hold of cargo, and the entire system of modern global commerce would grind to a halt under the weight of its own risk. The rules governing this high seas protection are codified in legislation like the Marine Insurance Act of 1963. Under Sections 7, 9, and 10 of the Act, this protection covers a wide net of stakeholders. It applies to the obvious cargo owners, but also extends to bailies handling the goods and mortgagees financing the voyage. To claim this coverage, a party must prove what the law calls an insurable interest. There has to be a real financial tether. If you benefit from the cargo arriving safely, or incur liability and suffer prejudice if it sinks, you have an insurable interest. When one company owns the goods from the factory door to the final destination, that legal tether stays perfectly intact. The complication arises with timing. A physical container ship takes weeks to cross the Pacific, but global financial ownership of that exact container can change hands in seconds, creating a severe disconnect between the cargo and its insurance. Imagine a fully loaded vessel halfway across the ocean. Right now, a company we'll call Seller A owns a shipment on board, and they hold a valid policy protecting it. While the ship is still thousands of miles from port, Seller A strikes a deal and sells those specific goods to Buyer B. Buyer B takes ownership of the physical items and naturally assumes that because the cargo is insured, that protection automatically comes with the purchase. But Section 52 outlines a specific legal trap. Selling goods doesn't transfer the insurance. Seller A is paid, so their insurable interest is gone. Buyer B holds physical risk but lacks legal paperwork, completely voiding the safety net. On the high seas, physical ownership and legal protection are completely separate entities. Assuming they are linked leaves the buyer exposed to total ruin. Moving the actual freight requires immense physical labor and careful coordination by dock workers at the origin point. Securing the financial side requires equal precision on paper. To actually protect Buyer B, the policy must undergo what the law calls a proper assignment. In marine law, properly means validly. The seller must explicitly and deliberately transfer the rights of the insurable interest directly to the buyer at the time of the sale. Securing a marine investment means making the administrative paperwork legally chase the physical cargo across the ocean to close the liability gap. Now, suppose on the final leg of the transit, rough seas hit. The cargo hold is compromised, water pours in, and the goods are ruined. Buyer B is suddenly facing massive financial jeopardy, holding the physical title to tons of destroyed, unsellable merchandise. When the mid-ocean sale occurred, Seller A and Buyer B executed a valid assignment of the insurance policy alongside the transfer of physical inventory. Because the insurable interest was successfully transferred before the damage occurred, the law recognizes Buyer B as the rightful policyholder. They are fully entitled to claim the cargo insurance. By adhering directly to Section 52, proactive legal maneuvering shielded the buyer from a catastrophic physical disaster, reducing it to a protected financial loss. Eventually, the bruised but surviving ship successfully arrives at its destination port, concluding the transit timeline. The reality of marine law is strict. Buying an insured container of goods does not mean you have bought the legal shield attached to it. An insurable interest is a non-negotiable requirement. If ownership changes mid-voyage, that interest must be deliberately and validly assigned to the new owner to stay active. Surviving the brutal realities of global trade requires ensuring that your legal policy is actively assigned to sail perfectly alongside your physical shipment.